Mike represents the Immigration Reform Law Institute, Inc., and you might just clarify for members here your relationship to FAIR as well.
Yes. Good morning. Mike Hethmon, Immigration Reform Law Institute. We are a legally separate but in tax terms supporting organization of the Federation of American Immigration Reform. We consider ourselves to be the only public interest law firm in the country exclusively working in the interests of citizens in immigration-related matters. I simply want to recap in 5 minutes my 2-hour testimony before the Prince Wiliam County Human Relations Commission on August 11th. I was the only person in this whole dog and pony show this morning that actually took the time, including the government representatives, to come down and engage in a dialogue with them. I think that's relevant because I made 3 points. One of them is immediately applicable to this exercise. There's nothing in the Commission's statutes or regulations that ever mentions the word immigration, immigrant, alienage. The only time the word alien is mentioned is when the regulations, your regulations, clarify that only citizens and legal permanent residents are covered by the Privacy Act. So the sense that this is testimony or witnesses or evidence is totally ultra-virus. This is a dialogue.
Excuse me?
This is, in my view, a dialogue between interested parties with the added moral hazard that you guys are associated with the government. That said,
having said that, perhaps you'd like to defer testifying before us then.
I am not testifying. I'm speaking, madam. So your interest in this is totally in the context of, is immigration law and are these activities a pretext for racial discrimination? And we discussed this with the panel in quite a bit of detail. Let me simply say that there is a long and complicated historical interaction in this country between the Civil Rights Act and the Immigration Act of 1965. I recommended this book, which is the comprehensive study on this by Professor Hugh Graham, collision course published by Oxford University. I would suggest that anyone who has not taken a look at Professor Graham's book really cannot consider themselves informed on the aspects of this issue. I will leave that point right there. Second of all, when we met with the Human Rights Commission, we did go into quite a bit of discussion about the technical issues, and really the bottom line in terms of this is that immigration law really is the law of citizenship discrimination. It's a law based on discrimination. It's based on discrimination between citizens and non-citizens, and that concept really, if you think about it, is an essential concept of both sovereignty and democracy. We went into a great deal of discussion on the technical points on that, and I'll be happy to answer any questions with the panel. Among the issues we discussed was, is immigration disguised racism and stuff? And I think in the context of this particular ordinance, and I am the drafter of this ordinance, it's on our website. We met with the citizens very early in this year. We've been working on this issue in Virginia since 2001. The lawful presence test in Virginia, the public benefits state statutes and stuff. That's all my shop's doing. Professor's little, Chisti's little book here that he passed out yesterday about this problem nationally. If you go through that, all the statutes cited in there, they do come out of our shop. So to the extent that there is some kind of mad scientist behind all this, we'll be happy to take credit for this. As to the racism behind charges behind this ordinance, the Eastern District answered that just a few weeks ago when they dismissed the case, like many similar cases that was brought against that. And they basically said that there was no prima facie case at all in the sense of a fear of deportation, fear of families being split up, or fear of services being denied. And
just for a point of clarification, he just simply said the plaintiff did not have standing. Is that right?
They did not have standing, but standing involves making a prima facie case of injury, as I'm sure you understand. So they are going to be able to refile their case when someone actually comes up with some evidence, which, of course, we're not talking about today. But this has been a similar trend. Just yesterday, the similar challenge was thrown out to the Oklahoma statute, which is considered to be the toughest, meanest one of its kind in the country by some people, which, of course, we were involved in. And the judge made some comments there, I think, that are absolutely appropriate to the context of this whole discussion. And he said that this court is convinced that the proper remedy for the injuries alleged by the remaining plaintiffs, which were businesses, churches, the National Coalition of Latino Clergy, and a long list of illegal aliens, all of whom are in willing violation of federal immigration law, is not judicial intervention. Rather, it is simple compliance with federal immigration law. Thank you very much.
Thank you very much.